a special guest today on Friday. My good friend, Blake Johnson, is here, and he's going to share some valuable information with you. Blake, how are you?
Hey, I'm doing great.
So happy to have you, my friend. Just a little bit of
Thank you.
background, Blake, so I can let everybody know how we know each other. Blake and I have met in fun circumstances because we're both LSU fans. I
Go Tigers.
Go Tigers. What a fantastic season, right?
Oh yeah.
Were you just over the moon? I was.
It took me. I lived on that high for a long time after they won the national championship.
Me too. And I was really excited about the fact that I'm going to share this while we're talking. If you guys can see this, let me see if I can move it around. Blake, I'm going to hide you and bring you back in.
Okay.
So you're going to be focused instead of this page here. So SinCityTigers.com, that is the website that basically allows you to go check out how Blake and I know each other, which is LSU. We have a huge crawfish boil. It was postponed. It was supposed to happen at the end of April. Guess what? It's about to happen at the end of May. We've got it set up to where now it's going to happen at the end of May. Everybody can come and participate. You can buy your tickets. We love LSU. Blake graduated from LSU, correct?
Correct. LSU Law School.
You know, I'm the vice president of the LSU Sin City Tigers, and I did not go to LSU.
Well, I found that LSU and Louisiana are kind of synonymous.
Yeah.
I actually got a new client the other day. He found me online because of my relationship with LSU, because he grew up, across the street from campus. Didn't graduate from
Right.
LSU, but he's like, but I know you're pretty much think the same way I did, because you're part of LSU. It's synonymous with Louisiana.
Yeah, my father was a coach at LSU for 17 years, assistant football coach under Charlie McClendon, and then
Mhm.
the head track coach. And so that's why I love LSU, because I grew up on the LSU campus. But it's so funny when I talk to people and they go, "How are you the vice president of the LSU alumni?" Well, I was kind of juiced in from the patriarch, Joe May, who is still with us at 86 years old and
Wow.
still attends our LSU events. And so I wanted to give a plug to everybody out there that we are going to have the crawfish boil. Typically 1,000 people. It's going to be at the downtown event center this coming May 30th, and you can get your tickets now. Just search, because this is a small window, just search at sincitytigers.com, or on Facebook you can basically go to Sin City Tigers after you search in Facebook. So Blake, I wanted to basically, you and we had a discussion. Gosh, it's probably been almost 6 months to a year since we've had this discussion. But I think this is a discussion to be had now, because Blake is a trusted estate planning attorney, and he is fantastic at what he does. And there's doctors, Blake, that are great at what they do, but don't have a bedside manner. I think that's the same way sometimes with attorneys.
Very much so. Or you hear it a lot with the CPAs too. They're very technically brilliant. And there's a lot of attorneys that are that way. They're great drafters, or they're great in their arguments, but they're not really good with the face-to-face.
Right. And what I appreciate about you is that you speak in layman's terms. You have a bedside manner when it comes to helping people, set up what everyone needs to do, which is set up an estate planning for their financial future and for their heirs.
Yeah, I'm a big advocate. It's called the plain English movement within the law community. It's pretty much, there's certain terms that have to stay in legalese because they have specific definitions that have been defined over, centuries of cases. But as much as possible, the movement is to let's make this as easy to understand for the general public, because, the idea is with older attorneys, hey, that's job security. My legalese that's a second language that I can interpret. That's what keeps me in the job. And my approach is, you know what? No, we need to explain to people. If we can explain it and help them understand it, I think we'll actually do better. Have better job security as attorneys because we have, we can help people understand what they're actually doing, so they trust us a lot more.
Right. Now, obviously, the good news is it looks like there's a light at the end of the tunnel. They're starting to talk about when we're going to be released from our bondage of home social distancing. You know what? My wife loves the fact that she knows where everybody is. Mm-hmm. She loves having all the chickens in the coop. And, it definitely has put a damper on our kids' social lives, but there's obviously everybody can get on each other's nerves, but then there's hey, everybody can kind of slow down and like be with each other, especially families and whatnot. So there's a glass half empty and a glass half full situation here. The situation with the fact that people have time to think about things that they need to do. One of them is planning for their financial future. And I'm sure there's been a lot of people that, think, oh my gosh, what if I were to get sick? What if I were to actually pass away? I don't have my financial house in order. So I'm sure that they're reaching out to you and saying, you know what, this is kind of a wake-up call. What do I need to do to get my financial house in order and be prepared to have it so that things aren't going through probate? Share a little bit about that, Blake.
Yeah, so just for clarity purposes, like I'm an attorney, I'm not a financial advisor. So I don't have any capacity as far as, what investments you should make and all that. But as far as getting your financial house in order from an estate planning perspective is, who's going to get that money if something were to happen to you? Or how can it be used if you become incapacitated? Let's say, you were to get COVID-19 and to be intubated and couldn't speak and couldn't make decisions. Who gets to make those decisions for you? Now, there's some defaults that doctors and the law goes to, but a lot of times we have to, go through court procedures to get people appointed to help, keep things going. Or if you actually pass away, then there's even more court procedures that have to go on if you haven't laid those things out. And right now the courts are essentially closed. So that's going to delay that process even more. So it creates even more problems. And so what we're trying to tell people is, hey, look, you need the two basic documents you need minimum is your financial power of attorney and your medical power of attorney. Now, the financial power of attorney, you should probably have an attorney draft because there's some nuances there that are pretty tricky because if you do it a certain way, you are authorizing the person you name to sign any document on your behalf, whether you authorize them to or not. So, that can be a little risky. But the medical power of attorney, the state of Nevada puts out a great form, and that's actually the form that hospitals prefer that you use if you're in the state of Nevada. So you just Google Nevada Healthcare Power of Attorney, and you can find that online, fill it out. You put who you want to make medical decisions for you if you can't make them for yourself. You get to, go through, and there's a couple of questions about, whether if you're in a coma, if you want to be let go, or if you want a feeding tube, and those kind of things. And you can either sign it in front of a notary, or if you don't have a notary, you can sign it in front of two witnesses as long as they're not named in the document. So that's something you can go and take care of right now, at least get the medical side of things done. Now, from an estate planning perspective, if you own a home or you got small kids and there's, you want to make sure the right people get them if something were to happen to you, then that's a conversation you need to have with an attorney. I don't know if you saw there was a story on, I think it was Channel 8 News a couple of nights ago. A young lady, about 35 years old, mother of some young kids. She got COVID-19, and she said the whole time she was in quarantine and had the illness, the only thing she could think about was that she didn't have her will and estate planning documents in place because she was worried about who would get her kids. And if you don't specify that, the judge gets to make that decision. And that can be a scary thought sometimes, is letting somebody else who has no idea what the situation is, even though they're going to do their best, use their best judgment, they have defaults that they should try to follow. And so it's not necessarily who you would want to take your kid. So those are just kind of some of the issues that come up. We are still operating, and our office is still fully open. We are just doing appointments virtually. Meetings like this,
like we're doing right now.
Yep, and we're able to get documents drafted, and then there's some great resources out there. You can, if you need to get them signed, you can print it off and go to a bank to get your documents signed. But that's still considered risky. The other thing we have done is we found there's websites that offer electronic notaries services.
Right.
So the one we particularly use is DocuVerify. That seemed to work well. And I'm actually trying to get one of my assistants approved as one of those electronic notaries, so you don't even have to pay their fee to use the service. But one of the great things about being in Nevada is they've always been on the forefront as far as the legal side of things go. So with the electronic notary and electronic signatures, and they're one of only, I think it's 10 states that authorize an electronic will. So there's hardly any states out there that approve that. Nevada is one of those. So we can get the full gamut of your estate planning documents done without having to leave the comfort of your home.
Isn't that something? I mean, what necessity is the mother of invention. I mean, before people didn't really have, and I just popped in www.trustedpa.com, correct, Blake?
EPA, you forgot the E.
Trusted EPA. Watch this. I'll have it. TrustedEPA.com. Magic. There we go. And here's the website. I'm going to go ahead and share that. Let's see here. Hey, everybody, if you have questions for Blake, we're on my Facebook business page live. If you do have questions in the public chat area, you can post them and I can see them. I can't actually, so there we go. Trusted EPA, estateplanningattorneys.com. That's the site you go to, and Blake has the ability to connect with you, and you can just register and connect with Blake right there. One of the things, Blake, that I learned from the fact that a will's not going to do it. A will is, you have to have a trust set up, especially with your homes, and everything needs to be that you have as far as assets need to be in a trust. Otherwise, it's still going to go through probate, correct?
Yeah, that's one of the biggest misconceptions we see over and over again is people think, oh, I have a will, so I'm good. And it's better than doing nothing, especially because the will is the only place where you can specify who's going to be the guardian of your minor kids. So it's still an essential step. But all the will is it's a letter to the judge that says, hey, judge, when I die and you get this in probate court, this is who I want to get my assets. And people think, well, I have a will, so it specifies who gets what, so we don't have to go through court. No, that's not it. It's strictly a letter to the judge of how things should be happening. Whereas if you create a trust, that is a private document that does not need a judge or any court hearings at all, as long as the trust owns the assets. So the problem number two is, people actually get the trust set up. Nevada is very, like I said, very on the forefront of trust law and education about that. That's why there's so many estate planning attorneys in the state compared to other states. And it's also very asset protection friendly. But the problem is people get their trust set up and the attorney doesn't really educate them well enough about knowing how to get the assets in the trust, which is called funding of the trust. And so they have this really expensive document that doesn't necessarily do what it says it's supposed to do, because their bank accounts are still in their name, their house is still in their name, their beneficiaries is still, their spouse or their kids, instead of having it flow through the trust. So that's the next step, is after you get it set up, actually transfer the assets. And that's something we help walk our clients through, is to make sure that actually their plan is actually going to work the way they want.
Right. So I had a situation recently where the homeowners had a trust. They had the property in a trust. But as far as the dissemination of funds, they did not have a checking account set up in the name of the trust.
Mm-hmm.
The money, since it's in the trust, has to go to a account that is set up under the trust, correct?
Yep. Correct. So, you're talking about escrow. Like, so when they sell the house, the funds are going to be released in the trust name. And if they don't have an account in the trust name, they can't cash that check.
So what do they do, Blake?
So at that point, hopefully they just go set up the trust account is what they need to do. I don't know why, but people have the biggest hang up about putting their personal checking account in the trust name. It doesn't make sense to me because it doesn't change anything except for, if people want to have a separate account from their spouse. I guess that's why they don't like it, but at least create a joint one in the trust name. You can each have your separate accounts on top of that. For instance, I had a client that long time client. They had their trust. We amended it, in June. The husband passed away in August, so it was good timing that wise. They've been clients of my dad's for 20 plus years, so they knew how things were supposed to operate. The only thing they didn't put in the trust was their checking account. And normally that wouldn't be a big deal because most of the time, most people don't put more than $25,000 in their checking account. But what happened is in January, they had a couple of businesses and they took distributions of that they'd invested in. And so the money all went into, wife deposited in the checking account. Well, she got sick and she passed away before she could move that to their investment account that was in the trust name. So now we're having to do probate for that one checking account because it has significant funds in it right now. And there's no other way to move it around. So that's why it's critical that all of your assets really should be in your trust name. And like I said, you want to keep one checking account in your name only, just so you have some fun money or whatever. Your spouse doesn't know what you spend it on. I guess you can make that work. If you're going to do that, at least put the trust as the pay on death beneficiary, because there's you can at least still do that, so that way it'll pay out to the trust when you pass away. But that is a critical thing that people often overlook, and so they think they're set because they have the trust now. But it's just a really expensive piece of paper if they don't have it actually, the assets titled correctly.
Got it. What happens when, and this is a personal client of mine, I'm not going to share a whole lot of information, but the beneficiary is doing some funky stuff. She's not sharing information with the heirs. She's moved properties with a probate attorney into her name. And not in the name of the trust, if there is even a trust set up. So I don't think, I know there was a will, but I don't think that there was a trust. So she's hired probate attorneys and moved properties under her name. How do you protect the other heirs that, have a right? I guess you have to go hire a probate litigator.
Yeah, so if it's done through probate, the judge is going to be the final deciding factor. So you usually can't move assets around without an order specifying how it's supposed to be moved. So if that's the case, that means she showed some pretty significant evidence saying, hey, this is the document that says that I get this. Whether that's forged or not is a different story. And so but they're supposed to notify the other heirs of at least the hearing date so they can come and make their appearances. So there are some restrictions there. On the trust side, there's not as much because we're not going through court. So you have to really trust the person that you're leaving the assets to. That's where the original word trust came from. It came from the Crusaders. They would leave to go on the Crusades and they would leave their land in trust with somebody else, with the idea that when they came back, they would give it back to them. Or if they passed away, then they would give it to their children or their heirs or whatever the case may be. So that is the biggest thing about a trust, is you really have to know the person that you're leaving in charge of the assets. If you don't have anybody that you can really trust and rely on, there are services that do that. So you can have either an attorney do it. I don't necessarily recommend that because it's usually a small office. Rob Graham comes to mind. He was an attorney here in town 5 years ago that got arrested for embezzling his client's money because he was the trustee. I would recommend an actual trust company because they have very strict procedures and checks and balances in place where it's more than one person that's looking at that and checking in, and they have accounting requirements and all that. So that would be the ideal situation if you don't have an immediate family member that can help you with that situation.
Got it. So do you practice litigation, or do you have partners that you refer to whenever there's a difference of opinion amongst heirs?
Yeah, so I don't do any litigation. I will do probate if it's uncontested. I'm very clear with the family when they come up. You come into the office, especially if it's family of one of the trusts that we we drew up. We put very strict provisions in there that say, hey, if you guys are going to fight about this, if you fight and you lose, you only get $1. So you're going to lose everything that you're supposed to get. And so that helps quell a lot of the fights that are going on. And then I also am up front, like in my office, there's no fighting. So, I'm going to read and interpret. I'll answer all the questions you may have. But if you're going to get angry and you're going to yell and scream and fight, take this out. You're going to have to go to another attorney. So you're going to spend double the money and you're going to have to get this out in court. And so that's another way we help mitigate that. But if it does come to that, then we will refer them out to some trusted partners that we have.
So for all of you families out there that you might not necessarily get along with your sis or your cousin, maybe you should talk to mom and dad who are going to start to disseminate all that money in the near future, and to have, good feelings and ultimately have everything in place. Mom and dad, go set up your trusts to make sure that there's no squabbling after the fact. Correct?
Yeah, if you can have a third party be the trustee, that mitigates so many problems, because what usually happens, the default is like, well, I'm just going to put my oldest child because they're the oldest child. So I'm going to put them in charge of the trust. And that doesn't even make sense half the time. They may not be good with money. They, may not get along with everybody else. They may, there's a myriad of things. So if you're going to put a family member and there's more than one kids, I usually say do at least 2 kids together. So they have to agree on how things are handled and both sign off on anything. But if you can get a third party to do it, a sibling of yours, sibling of the parents, even a cousin or somebody else outside of it, if you don't want to pay for the third party to do it, that's usually a better situation, because the blame can go on them for the way things were handled and it doesn't affect the immediate family dynamic.
Got it. Wow. I was watching, I believe it was 60 Minutes or some show recently where, there was a situation where a lot of people are being taken advantage of, elder abuse, where people are having their assets, basically stolen by parties that come in to say that they're going to take care of you, but then they put you in a home, they start managing all your money. Does a trust protect people in that respect, Blake?
To a certain extent, because at least you've specified who you want to make those decisions. Now, there's still the predators out there that will come in and they'll present you with the new power of attorney. And so you'll sign that, and then they'll take that power of attorney and go and amend your trust without your knowledge. So they can still do some of that stuff. But if you have the documents in place ahead of time, then we can usually come back and say, hey, no, they weren't clear in their right mind. This is who was initially put in. Why would they disinherit all of their kids? So at least on the litigation side, we can go after that person and help mitigate some of it. But yeah, the ideal thing is, don't let mom and dad sign that stuff, from a caretaker. Say, hey, you guys don't sign anything without us looking at it. We need 3 signatures or something, when you contact a company. Also do some vetting, ask around, make sure they're a quality company. You definitely do not hire the individuals. They're the most likely to produce these type of scams. So make sure they're licensed, make sure they're insured. All of those things help protect the people that way.
Got it. Man, I could ask you tons of questions, but I know you're probably going to be having some more Zoom calls and conferences. Right, Blake? I mean, have you had an uptick of people really thinking about, what do I need to do to protect my family?
Yeah, it's one of those things that anytime there's a natural disaster or a health scare like this, people tend to think about those things like, oh shoot, I never got that done. I didn't get the life insurance that I was going to say I was going to apply for. I didn't get my will written. I didn't get my trust. I didn't get my power of attorney. And at that point, sometimes it's almost too late. But like I said, we can do everything virtually, so we can still help you get that done. And if this did make you start thinking about it, just because we're on the mend doesn't mean you should put it off. This is not something that only happens that you need to worry about if you're old. It's called a living trust because it changes throughout your life, but it's estate planning. It's planning for while you are alive as much as it is for when you pass away. So don't put it off. If you've had that thought, you really should at least sit down and have the conversation with me or another attorney. I do complimentary consultations, 30 minutes, just to see if it even makes sense for you to move forward and do anything.
Right. So here we have Blake's website, trustedepa.com. You can log on to trustedepa.com. You got the phone number for Utah and Las Vegas. And then we have, I know you do podcasts, you have the contact button. So folks, it's a wake-up call, definitely. And Blake is absolutely a trusted friend and attorney friend of mine. So you're in good hands by meeting with him and making sure that your estate planning is in order. We too are conducting online. We're doing a lot online now as well, Blake. I actually have mayteamlasvegas.com right here, where you as a homeowner or a home buyer can log on to our website, mayteamlasvegas.com, send me a text first, and then just click the Zoom link, and then we'll connect and we can conduct a face-to-face consultation. I can conduct a market analysis for you to show you what your home is selling for by comparing other homes similar to yours in your neighborhood. I can then also help buyers conduct virtual showings. We as real estate agents have a lot more information on our side to be able to really dial in a search to help you buy your next home. And the interest rates are fantastic right now. So again, glass half full, glass half empty. The positive side is that we're going to come out of this. The positive side is that interest rates are fantastically low and you can take advantage of an opportunity. And also, I believe there's going to be some inventory coming on the market because people, just like they need to think about estate planning, they start thinking about, you know what, I think it's time for me to downsize. Or, you know what, I want to take advantage of these low interest rates and upsize because I'm going to have, a new baby coming. Well, this is an opportunity, folks. I know it's kind of hard. You kind of stick your head in the sand when things like this happen and you're absolutely locked down, but it also gives you time to ponder and time to think and time to reach out to trusted advisors like Blake and like myself. So,
well,
Blake,
and I would add to that if you, if everybody is putting their head in the sand and not doing anything, there's probably more opportunities for you. You could probably negotiate better, on either side of the deal, whether you're selling or buying, just because there's not as many people fighting for that same thing. So it's actually, a great opportunity to do these things when everybody else is sitting still and not taking action.
Absolutely. There are those that are refinancing and taking care of, they at a 3% interest rate, you can refi into a 3%. What if you have a 4.5 or a 5% interest rate from before? We have, if you go to mayteamlasvegas.com, we can obviously connect you with Blake, but you have his website there. But, please use this as a resource because we have the lenders. We have lenders that are actually doing no human interaction signings. They have notarization of all the loan documents. Our title companies are now conducting Zoom escrows, and the only document you have to sign, you actually drive up to the escrow officer's office. Escrow officer walks out, has you physically sign the note and the deed of trust, and you drive off. It saves a lot of time. I have to say that there are positives coming out of this because we're being more efficient because we have to.
Well, and I hope that continues as we come out of this, as people realize, we can do a lot of this stuff online. We can help save a lot of cost and driving and time and everything else. And I think we are going to see a shift overall in every industry to say, all right, how can we implement this technology we've already become familiar with?
Absolutely. And I embrace that shift because there are times when I'll go to someone's home and try to, I hate paper. I want to do it paperless because I want to connect and I want to show you visually what I'm seeing. And we can do that from the, comfort of our own home. You don't have to have me come over. until it's time to help you stage the property
Yep.
and take virtual photos and really eliminate a lot of time and energy. We can do it virtually. And now that people know how to use Zoom and you feel more comfortable using Zoom, you can connect with folks like Blake and I in conferences.
Okay. I think that's I agree 100%.
Well, Blake, I really appreciate it, man. Hey, everybody, if you have any questions, go to trustedepa.com. If you have any real estate questions, go to mayteamlasvegas.com. And everybody stay safe out there. All the best to you and your family, Blake.
Thank you. Appreciate it. Thank you for having me on.
And maybe we'll see you on May 30th and have a little crawfish, a little Zydeco music, get out in the fresh air, and laissez-les bon temps rouler.
Oh, that would be fantastic. I'm looking forward to it.
Me too, man. Thanks a lot. We'll see you later, and thanks, everybody.